Thank you very much for that introduction. I will speak about not only books, but also about other cultural objects. And in that way, I will widen your scope of this conference. The matter of restitution is probably well known to all of you. For example, our main organizer, Peter Sjöqvist, has written an article on restitution of books as agreed in the Peace of Oliva that was concluded in 1660 between Sweden and Poland and some other states. I myself have written a book called The Parthenon Syndrome, which is also about cultural heritage and restitution of cultural objects. I became interested in this subject since the president of Czechoslovakia, Václav Havel, visited Stockholm in 1990. It was widely believed at that time here in Sweden that he would ask for the return of the Silver Bible, the Bible that you see on front of this slide, and that he would ask for the return of it because it was taken by Swedish troops in the Castle of Prague in 1648, just before the Peace of Westphalia was concluded. And I was working as a legal advisor at the Ministry for Foreign Affairs at the time, and I was asked to write a memo on whether President Havel could actually ask for any legal basis for such a request. And I noted that the taking of war booty was legal in the 1600s, and that from a legal point of view, we could not retroactively do anything about that. Moreover, the Silver Bible had only been in Prague for about 50 years, while it had been in Sweden for 350 years. So this extremely beautiful Bible was created in the year 500 or thereabout in present Italy, not in Bohemia, not in Czechoslovakia, but in Ravenna, in fact, then the capital of the Ostrogoths. So there was no existing home country to return the Bible to. But of course, as a matter of friendly policy, we could return it. But in the end, there was a national sigh of relief. Havel did not, after all, ask for it. The precious Silver Bible is today kept here in Uppsala at the Carolina Rediviva Library, and it's considered to be part of the Swedish national cultural heritage. The war booty from Prague also included another Bible, the so-called Devil's Bible. And here you see one picture from that Bible, and you understand why it's called the Devil's Bible. This devil or book is of gigantic proportions, therefore also called Codex Giganteus. It contains a large picture of the devil, as you see, and it was created in a monastery in Bohemia in about 1120. In 1648, it had been in Bohemia for about 530 years, to be compared with the 375 years, much less, which it has now spent in Sweden. So from a political point of view, the Devil's Bible could well have been restituted to the Czech Republic. But President Havel did not ask for it, not at that time at least. This Bible is kept in Stockholm at the Royal Library and also considered to be part of our cultural heritage. I will now approach my topic from basically a legal perspective. Law is relevant because we have to consider international claims across borders. Claims are being made for the return of cultural objects that have been transferred to other countries. There is currently in the international community a trend which accepts restitution of cultural property. President Macron of France announced in 2018 that cultural objects taken in colonial times should be restituted to Africa, to the countries of origin. And as we know, there has in the colonial and imperialistic past been a flow of cultural objects from Oriental and other countries to Western museums. Many states from all continents have since long put forward claims for the return of cultural objects. Today, it is common to listen to such claims and to respond to them in a positive manner when circumstances indicate some form of wrongdoing in the historic past. Western museums have often argued in terms of internationalism and globalism, stressing that they legitimately display the universal common heritage of all of us. This universal approach, they tend to argue, prevails over any cultural nationalism. Nevertheless, they have come to realize that if objects have been taken in situations which are immoral or unlawful, the correct way is to handle the issue through negotiation. Therefore, we have this trend in cultural diplomacy of agreements between museums and state organs, more often than not leading to a change of status quo. So consequently, cases of restitutions are plentiful nowadays. Restitution is a rather clinical and objective term, while repatriation is more subjective and nationalistic, indicating that what is being missed belongs to us and is part of our national heritage. In the famous case of the Parthenon marbles, the Greek government has used the less nationalistic formula of reunification, arguing that the monument itself needs to be reunited with its parts abroad. This is an argument of cultural belonging. Greece has since 1835 sought the return of the Parthenon marbles from the British Museum. The Greek claim for restitution has served as an example for others. Since the 1950s, other countries around the Mediterranean have followed suit: Libya, Italy, Turkey, and Egypt. Similar claims for restitution has been made by Ethiopia, Nigeria, Peru, and other countries. And these claims are perfectly legitimate. They are brought forward bona fide, in good faith. Although cultural objects in a global perspective belong to our common heritage, such objects also belong to the geographical regions of their origin. I have used the word region for a purpose. Cultural property may not be linked to a current state, but it will always be linked to the region of origin. A great deal of what states wish to label as belonging to their cultural patrimony was produced before the modern system of states came into being, by members of societies that do not longer exist. Cultures die, but their remnants live on. The modern inhabitants of a region, even if their DNA does not confirm a link to a cultural past, feel the cultural connection. The perception of belonging is legitimate, and the modern territorial state can undertake a responsibility for the protection of its national heritage. At the same time, the display of cultural property is an issue for all mankind. If the property is legally acquired or acquired under morally acceptable circumstances, it could legitimately be displayed anywhere in the world. I have used the term legitimate in its colloquial meaning, being acceptable from a moral and political point of view. The term legal is something else. Formal legality is the same as lawfulness, while informal legitimacy indicates something less than what is legally binding. International law is very weak and undeveloped in the field of restitution of cultural property. The rules are policy-oriented. It's a matter of policy and practice. Every case where restitution has been claimed must be investigated ad hoc, taking into account its particular historical circumstances. Such an investigation may unearth both legal and moral features. We are thinking of cultural objects that are to be found in museums of the Western world in cities like London, Paris, Berlin, New York, or Los Angeles, or in private collections anywhere. Claims for restitution are being made, but the counter-argument is that the object in question now belongs to the possessor. The museum, the art dealer or art collector in question will argue that the object has been purchased in good faith, bona fide, from someone else who was believed to be the rightful owner. Therefore, the possessor claims ownership. So this is a sensitive issue. There is an emerging regime of international law for protecting the cultural heritage. The regime focuses on three things. One, conflict resolution between conflicting parties. Two, safe return of cultural objects to legitimate claimants. And three, criminal justice and responsibility meted out to individuals that have acted in bad faith, mala fide. Some claims seem to rectify the wrongs of colonization, affecting particularly indigenous peoples now seeking to recover objects looted from them. For example, the British military expedition in Nigeria of 1897 looted scores of bronze sculptures from the city of Benin, artifacts which found their way into museums and private collections in Europe and the United States. Claims for restitution have been made since the 1960s. The Benzin bronzes are on display in the British Museum and have been exhibited at the Royal Academy of Arts in London and in other places. In Gothenburg, a PhD thesis in archaeology was presented in 2016 on the subject of the Benin bronzes. It was written by Staffan Lundén, a teacher at the School of Global Studies, Gothenburg University. The thesis was titled Displaying Loot, the Benin Objects and the British Museum. Lundén shows how the Public Relations Department of the BM argues that the display of the loot has been a good thing. We in the West have learned to appreciate African art, and in a sense, this cultural awareness makes up for the looting itself. But Lundén argues that the source material reveals a murkier and more sinister past than the museum is willing to disclose. The plunder of Benin City was not an isolated event in colonial practice. In 1868, when the British captured Magdala in Ethiopia, they seized an enormous war booty. Likewise, later in the 1800s, the capital of Ashanti in modern Ghana was sacked and a large booty was taken. The looting in China of the Beijing Summer Palace in 1860 was carried out by French and British troops. And in 1900, during the suppression of the Chinese Boxer Rebellion, a wave of looting followed by European and other troops in Beijing. Since there for a long time was no legal prohibition against the taking of spoils in war, Swedish troops during the 1600s seized artifacts and books in Denmark, Poland, Prussia, and Bohemia. A doctoral thesis in the history of ideas was published at Stockholm University in 2015. It was titled Krigsbytets biografi, the biography of war booty, and was written by Emma Hagström Molin. The dissertation explores how war booty was understood during the 17th century. Ownership of booty as a consequence of military victory was taken for granted. Hagström Molin's investigation mainly concerns books. Looting of books was conducted also by the Swedish king, Gustav Adolphus, and his field marshal, Carl Gustav Wrangel, during their military campaigns in Livonia, Prussia, and Denmark. This was in the period 1620 to 1660. Wrangel organized a booty and book collection at Skokloster Castle, not far away from here, southwest of Uppsala. Wrangel's collection at Skokloster included books seized from Danish noble families like von Rothkirch and von Barnewitz. At the time of the Peace of Westphalia, and later, the writings of Hugo Grotius, the Dutch so-called father of international law, was very influential. Grotius taught that booty could be taken as long as peace negotiations were not concluded, and the transfer of ownership of the booty was a fact after 24 hours of possession. But after the Napoleonic Wars, during the Vienna Conference of 1815, a new attitude of international morality and cultural decency took over. Cultural property taken during the war was returned to its earlier locations. For example, the sculpture of the bronze horses in front of the St. Marcus Church in Venice, taken by Napoleon's troops, were returned. But the feeling of moral imperative needed to be translated into legal obligation. Later in the 1800s, a development on the laws of war started. In 1874, a declaration on the law of the battlefield was adopted by 15 countries in Brussels. The declaration prohibited destruction, plunder, and transfer of cultural property. But the Brussels Declaration never entered into force. States were not ready for it. Nevertheless, it influenced the work of the so-called Hague Peace Conference of 1899. It was not a peace conference in the sense that it ended a war, but in a more general sense. One of its documents, the Land Warfare Treaty, prohibited all forms of looting, and its Article 56 prohibited every seizure and destruction of cultural, historic, and religious objects. After almost 50 states had ratified the Treaty of 1899, they were bound by it, and other states were soon also bound by it by a corresponding development of customary law. The days of war booty had come to an end, and at least from the perspective of international law, that was the case. The only exception was the right to seize the enemy's weapons, flags, and other military insignia. A second Hague Peace Conference was held in 1907, and the new Treaty on Land Warfare had an extensive protection of cultural property. For example, the new Article 56 stated that all seizure and destruction of historic monuments, works of art, and science is forbidden. And the Hague Regulations of 1907 are still in force today. The protection of cultural property in armed conflict has in modern times been updated in the Hague UNESCO Convention of 1954 and in later additional protocols to that convention. And in 1972, 2 protocols to the Geneva Conventions on War were adopted. And in the first protocol, it was stated that it is prohibited to commit any act of hostility directed against the historic monuments or works of art which constitute the cultural heritage of peoples. Although the main purpose in that provision is to prevent destruction, also the taking and transfer beyond borders of such cultural property is prohibited. More recently, the legal focus has been directed at the booming art market and at trafficking of cultural objects. Emphasis has been placed on rules for the restitution of stolen property or return of illegally exported property. This is the object and purpose of the 1970 UNESCO Convention signed in Paris, and also of a convention signed in Rome in 1995. The Paris Convention focuses on administrative procedures, while the Rome Convention, drafted by the legal institute UNIDROIT, has a more legal approach. Restitution there is granted in cases where cultural objects have been illegally exported. The former possessor, often an art dealer, can be compensated if he was in good faith and showed due diligence when he purchased the object. Just to argue good faith is not enough. You also have to show due diligence. Unfortunately, the stakes are often too high in the commercial art world to rely on mediation and other friendly dispute resolution techniques. Litigation and criminal justice in courts is needed. The Rome Convention relies on court procedures, but the convention is not widely ratified and thus not binding for many states. In contrast, the older UNESCO Convention of Paris is widely ratified, but also more general and less effective. It's difficult to create an effective legal regime of cooperation and dispute settlement. One problem is the adversarial terminology in this field. We have common heritage versus national heritage, cultural globalism versus cultural nationalism. And in general, it's the universal versus the parochial. The matter is still very sensitive. Western museums, as I already noted, often argue globalism, that they legitimately display the common heritage of us all. Nevertheless, they are open to negotiations. That is why we have this trend of agreements between museums as such and between state organs and museums. This trend of agreements has emerged as a natural response to a repeated practice of claims for restitution. And this practice has developed into a modern phenomenon, the Parthenon syndrome, as I've called it in my book on the topic, namely an awareness that what did not seem possible in the past is possible today, and that negotiations can, in the end, lead to restitution. So, there we are. Many states and museums are at present claimants, acting in line with the Parthenon syndrome, hoping for the best. I thank you.
We have some time for questions, either here in the room or on the chat, and we have our cube throwers at the ready. So who can I invite to give a question?
Okay, so.
Thank you very much for your presentation. I was thinking a lot about your comments on the private collector, and there was a recent case you might know about, Martin Skoyen, apologies if I'm mispronouncing the name, a Norwegian collector who managed to, quite out in the open, function as a collector with dubious due diligence practices, and has only recently been held to account with 83 of his objects being seized by the Norwegian police. How do you think such collectors manage to operate with gleaning legitimacy, perhaps, off of public institutions and research institutions? How is this able to continue in the current day?
Yeah, there was a time when no one asked the difficult questions. And very often, for example, in Sicily, in wintertime, when the archaeological people went some other place, went home, then came the gangs of the mafia and unearthed cultural objects from the ground. And they had a link to art dealers in Geneva and Switzerland. And the Geneva airport there was collections of these things. And after a time, they could go on further, very often to London. And the museums in the United States, for instance, the the museums in New Orleans and in Los Angeles. The Getty Museum I'm thinking of was the first where they had a curator who was taken to court, to justice in Rome. And after that trial, things started to change. And not only the curator at the Getty Museum, but also other curators were looked into how they had acquired, how they had bought these things all over the world, but mainly in London, Geneva, Paris, and other Western big cities. And then came this trend along, which the museums for such a long time had been negative about, because they said, we have the stuff, it's in the global interest, we can do what we like.
I was thinking, when it comes to cultural heritage, to what extent do you take public opinion into consideration, like returning war booty and cultural heritage? Because a lot of people advocate very strongly for that cultural heritage, such as books, should be returned to their home regions. So do you take public opinion into consideration, and to what extent?
Yes, I think public opinion has been very crucial in this case, because when this discussion started and came up in the open, the museums were afraid of the public opinion. The museums wanted to have the public opinion to back them, and that was exactly the reason why the practice changed. And I think there is a connection between the popular interest in human rights and the NGOs, the different organizations asking for human rights. They also support the return of cultural objects which have been taken under dubious circumstances. So there is a connection with the public opinion, surely.
Are there any questions on the chat?
There is one question coming in from the chat, and I'm going to read it as it exactly as it came in. Sometimes books and documents are acquired in the field for information, such as for charts and maps. Where does this sit in the concept of looting?
Well, if it's that's obviously a good thing on the surface of it. If it's used in order to hide something in between, which is another kind of practice, one should go at it from a legal point of view. But I haven't heard any problems with regard to these cases being like some fishy or dubious or anything like that. So I don't think it's a big problem, actually.
Thank you.
Thank you very much again for your presentation and also for answering these questions. Would you join me in thanking Professor Bring?
Thank you.